Good morning, everyone. It is Tuesday, December the 13th, 2022, and I'd like to call the Board of Funeral Directors and Embalmers meeting of Tennessee. Mrs. Bohannon, if you'll call the roll, please.
Fred Berry.
Here.
Anthony Harris.
Here.
Tanya Skellhames.
Here.
Chris Lee.
Here.
Scotty Porsche. Charles Rahm. Pam Stevens. Mr. Vice President, we have a quorum.
Thank you, Ms. Bohannon. At this time, we will accept a motion to adopt our agenda as presented.
So moved. Second.
Have a motion by Mr. Berry, second by Mr. Lee. All in favor say aye.
Aye.
All right. The minutes were sent to all of us. Give you a moment to review those. If there's any changes, we'll talk about those. Otherwise, we'll accept a motion.
Move we approve. Second.
A motion by Mr. Berry to approve the minutes as presented, second by Mr. Lee. Any discussion? All in favor?
Aye.
Any opposed? All right. We'll move to our legal report. Mr. Troy Bryant, we'll turn it over to you, sir.
Thank you. The first complaint number is complaint number 2022-038-411 against a funeral establishment. During the course of a routine inspection, the investigator determined that the manager for the respondent establishment had allowed their funeral director's license to lapse and had been expired for 21 days. As a side note, as board members may remember from last month's meeting, this is one of those silo locations in which the same individual was manager for 3 locations. 2 of them were on that previous legal report. This is the third one. It just came in a little later. So based on that and based on last month's determination, we would recommend a $250 civil penalty, authorized via consent order, and formal hearing if necessary.
Do we accept council's recommendation?
Second.
I have a motion by Mr. Berry and a second by Ms. Stevens. Any other questions? If not, all in favor?
Aye.
Any opposed? Next.
Next complaint is complaint number 2022-041151. Complainant, mother of the deceased, stated that her son's life insurance had been deposited without permission. Complainant provided little additional information to support the allegation. Respondent replied stating the decedent's father presented a check from the life insurance company on April 27, 2022, in the amount of $20,021.26, and the check was made payable to the deceased estate, and the father endorsed the check. The check was deposited into the establishment's account for the cost of the service, and later a refund check was issued to the decedent's father, the amount of $15,104.26, the principal minus the amount for the services. Respondent provided that the beneficiary of the policy of the decedent was the paternal great-grandfather of the deceased. At the time of the decedent's death, the great-grandfather had also passed away. Respondent stated that the next of kin of the decedent's great-grandfather, his daughters, gave decedent's father permission to use the proceeds to pay for the funeral services. Further, respondent provided that the father of the deceased stated that the complainant does not have any claim to the insurance policy, as the deceased had been in custody of the father continuously from age 9 until the decedent's death. Respondent provided a copy of the insurance policy, death certificate of the great-grandfather, and a letter signed by the great-grandfather's daughters giving permission to use the proceeds of the policy to handle the final arrangements. Based on the above, we would recommend closure.
For approval.
Second.
I have a motion by Ms. Stevens, a second by Mr. Berry. And I've just got a quick question. The balance of that check, do we know, was it reimbursed correctly?
With the information provided, there was no additional statement or claim that was not the entire amount that was owed, and that it had gotten to the family where it needed to go back to.
Okay. Any other questions? All in favor?
Aye.
Any opposed? Next.
The next 2 are the same set of facts and occurrences. They are complaint number 2022-041851 and 2022-041861. Excuse me. This complaint was opened following the establishment's routine inspection. During the inspection, the field representative discovered that the respondent individual had allowed their funeral director and embalmer's license to expire on June 30th, 2022. The individual reinstated their license on August 16, 2022. The field representative stated that the individual did not meet with any families during the period of July 1st through August 15th, but that the individual did handle 6 embalming cases during that time. The complaint was also opened against the establishment for aiding and abetting an unlicensed director and embalmer during the period that the individual's licenses had lapsed. The respondent individual replied stating that they admitted they had embalmed 6 people during the period and that they had an expired license and accepted responsibility, adding that they did not intentionally violate the statute. Respondent stated that they were unaware that their license had expired, otherwise they would not have provided embalming services. Respondent stated with the initial notification of renewal they either did not receive it or had misplaced it. Respondent provided that upon receiving notification that the license had expired, the license was renewed, and respondent apologized again for the oversight and stated that it would not happen again. Based on the above, we would recommend a $250 civil penalty to be assessed against the funeral establishment and a $250 civil penalty be assessed against the embalming license, authorized via consent order and formal hearing if necessary.
Move that we approve council's recommendation.
Motion by Mr. Berry, second by Mr. Lee to accept legal's recommendation. Any other questions? All in favor?
Aye.
Any opposed? Next.
The next complaint number is complaint 2022-042691. Complainant alleged that the respondent establishment was allowing non-licensed employees to perform licensed activity. Complainant claims that when they brought this to the respondent's attention, they were fired. Complainant further alleged that they were, quote, repeatedly referred to as an offensive term, and also alleged that proper ID tags were not placed on decedents and were instead identified with their names written on strips of duct tape. Due to the nature of the allegations, the complaint was not sent for response, and an investigation was conducted. The investigator met with the complainant, who stated that they had started working at the respondent establishment in September of 2022, and that during their time there, 3 employees, none of which were licensed, made funeral arrangements without a funeral director present, and that one of the employees also performed cremations without a licensed funeral director present. Complainant stated that they performed most of the embalmings at respondent establishment, and they were not working. An apprentice funeral director and apprentice embalmer performed the embalmings under the direction of a licensed embalmer at respondent establishment. Complainant alleged that the embalmings done by the apprentice embalmer were unsatisfactory. Complainant stated that when their concerns were raised to the staff at respondent establishment, they were terminated. Complainant finally stated that after attending a cookout where members of the respondent establishment were present, one member of the staff referred to them as an offensive term on, quote, several occasions. The investigator met next with the office manager of respondent establishment, who stated that complainant was hired on August 24, 2022, and worked as a licensed funeral director and embalmer. The office manager stated that during the 7 weeks of complainant's employment, for only 3 of the 7 weeks did complainant work an entire 40-hour week. The office manager stated that complainant regularly missed work due to personal issues. The office manager added that they became concerned about complainant's hostile actions with other staff members. This all led to complainant's termination. The office manager provided that no cremations, embalmings, or funeral directing had occurred without a licensed funeral director or embalmer present. The manager, who the complainant had alleged called them the offensive term, emphatically denied ever calling complainant that. To support their statement, the office manager provided text message correspondence between her and complainant and time cards for the complainant that showed several weeks where complainant failed to complete a 40-hour week. Additionally, the office manager provided that the establishment had even agreed to pay complainant's first month of rent in the interest of helping him move to the town in which the respondent establishment was located, and provided a receipt for complainant's first month of rent. The investigator spoke next to the owner and manager of respondent establishment, a licensed funeral director and embalmer. The owner stated that complainant had caused problems since their first week of employment, stated that they were never on time and did not work the required hours. The owner stated that there was a dress code in place for staff members to present in a professional manner, and that complainant never dressed in an appropriate manner, even after the owner had spoken to them directly about it. In total, the investigators spoke to 7 different employees at respondent establishment. Each corroborated the professional concerns expressed by the owner and office manager, and each denied the allegations regarding unlicensed practice and stated that they never heard the office manager refer to complainant with the offensive term. Upon completing all interviews, the inspector examined 37 funeral files and 18 cremation files. The investigator found no evidence of unlicensed funeral staff members making funeral arrangements or performing cremations. Based on the above, we would recommend closure.
Questions or discussion?
Accept council's recommendation.
Second.
I have a motion by Mr. Berry, second by Mr. Lee to accept legal's recommendation. All in favor?
Aye.
Any opposed? Next.
Next is complaint number 2022-046251. Complainant, daughter of the deceased, stated that her mother passed away on October 25th, 2022, and had a pre-need agreement with respondent from 2008. Complainant stated she spoke with the owner of the establishment to make arrangements on October 26, 2022, and alleged the following. 1. Respondent did not provide complainant a price list during this meeting. Complainant stated they requested a price list repeatedly on October 26th, October 31st, November 2nd, and November 3rd. Respondent stated that as of November 3rd, the day they had filed the complaint, they still had not received a price list, and said that after calling respondent establishment, the secretary stated it couldn't be emailed but would have to be mailed. Complainant stated she did not receive the general price list until November 9th. 2. Respondent informed complainant that a steel box was required for burial. Complainant questioned this because their father and brother had been buried in the same cemetery and a steel box was not required at that time. 3. Respondent, quote, hurried through the contract and the writing was difficult to read. Immediately after signing, complainant stated they requested a copy of the contract and a respondent indicated it would be sent. Complainant states they did not receive a copy of the contract until it was requested again on October 31st, 2022. It was emailed to them at that time. 4. Respondent asked complainant to name 6 pallbearers. Complainant identified 4 people, but wasn't sure who could fill the final 2 spots. Complainant contends that respondent stated that wouldn't be a problem and that they could have 2 other employees there to fill in. Complainant stated that this did not occur and that her 2 nieces had to fill the final 2 spots because no employees were available. Complainant provided a photograph to show that the nieces were in place as the final 2 pallbearers. And 5, complainant stated that the graveside service was planned for 2 o'clock, that there were no tents and chairs, and that at 2:08, the casket was still in the hearse. Complainant provided that the truck with the casket lowering apparatus did not arrive until 3:20. Respondent replied stating that to the best of their knowledge, an outer container was required. Respondent stated that they had reached out to the cemetery to confirm whether this was the case, but contended that they never received a call back. Respondent stated that they ordered the container hoping that someone would tell them at the burial whether it was required, as it was just a steel box and could have either been installed or taken away easily. Respondent stated regarding the setup at the cemetery for the graveside service, they had recently hired a new independent service for graveside setup. Respondent stated the independent person erroneously believed he had time to set up everything due to the assumption that there was a chapel service. It was a graveside service only with no chapel service. Respondent stated that they have refunded to complainant charges for the steel box, its setup and taxes, and a third-party cost that respondent had already paid for that complainant chose to cancel. Legal contacted complainant to determine whether the refund had been received and confirmed that as of December 10th, 2022, complainant had received the stated refund. Based on the above, we would recommend a $3,500 civil penalty, authorized via consent order, and formal hearing if necessary.
I'll make a motion that we approve council's recommendation.
All right, I have a motion by Mr. Berry, second by Ms. Haynes. Any further questions? All in favor?
Aye.
Any opposed? Next.
Next complaint is complaint number 2022-046591. Complainant alleged that respondent did not submit a death certificate to the son of the deceased and alleged that the insurance that paid for the services was fraudulently signed. Complainant stated that, quote, it was believed, end quote, that the son of the deceased was the beneficiary and was intentionally excluded from that information. Respondent replied stating that the person in charge of the decedent's arrangements was the decedent's brother. Respondent stated upon completion of the arrangements, insurance verification through the insurance company was conducted to make sure that the benefit amount was enough to pay for the funeral expenses. Respondent stated following verification, the insurance beneficiary was determined to be the brother of the decedent, not the son of the decedent. Respondent further stated that the son had never been named as a beneficiary or even a secondary beneficiary of the policy. Respondent attached a copy of the insurance policy and documentation from the insurance company to show that the brother of the deceased had signed to receive the proceeds of the insurance fund. Based on the above, we would recommend closure.
We know what the relationship the complainant has.
I'm trying to recall if that was included. I think this was another one where the information provided by complainant was pretty sparse. I want to say, actually, give me 1 second. I can pull that up really quickly because I do not want to tell you the wrong thing. Reading over the complaint, it does not provide information as to what the relation is between the complainant. The last name of the complainant is different from the last name of essentially everyone else involved. So it's hard to say, and that information wasn't provided in the complaint.
Thank you. Any other questions? Need a motion?
Move we approve council's recommendation.
Second.
I have a motion by Mr. Berry to accept legal's recommendation, second by Mr. Lee. All in favor? Any opposed? Next.
All right. The next one is 4 together. They are complaint number 2022-039191, 2022-039231, 2022-039261, and 2022-039281. And also, just for clarification, the individual in complaint number 9 and 10 is the same person. That's their funeral director license in one, and their embalming license in the other. Complainant alleged unprofessional conduct against Respondent Funeral Home and Respondent Funeral Director / Embalmer number 1 and Apprentice Funeral Director number 2. Complainant provided that the deceased passed away on February 6, 2022. The children of the deceased and their uncle, brother of the deceased, wanted a viewing of the deceased prior to the final disposition of remains, which was cremation. According to complainant's counsel, the uncle assumed the responsibility for all payments and, quote, took the lead in the desired arrangements and clearly communicated the family's wishes to respondent. Complainant said they began working with funeral director / embalmer number 1 and claimed that the respondent confirmed via telephone and other messages that the respondent staff was aware of the family's wishes for a viewing and funeral ceremony. Complainant stated that this respondent funeral director called and left a message on one of the family's phones acknowledging their wishes. Complainant contends that the viewing ceremony was scheduled for Friday, February 11th, 2022 at 4 p.m. However, 2 hours before the purported viewing ceremony was to take place, respondent called complainant family and requested they come to the respondent establishment office. Complainant stated that upon arrival, the family was informed by respondent that they had, quote, mistakenly cremated the deceased earlier in the week before the family had an opportunity to view the deceased. Complainant stated that respondent provided a container holding the cremains of the deceased and indicated there would be no charge for the cremation. Complainant attached as an exhibit text and audio recordings of the voicemail left by funeral director / embalmer 1. The voicemail states in full, quote, hello, this is funeral director / embalmer number 1 with funeral establishment. This message is for Mrs. Next of Kin. Next of kin, I just finished speaking to Mrs., presumably other member of the family, who informed me that you all did want to have an identification viewing for your mother, and I was calling to see if I can go ahead and set that up for either this coming Friday at 4 p.m. And I also let her know that the charge would only be $125 in addition to the cremation and the 2 certified death certificates. If you could please give us a call back. If you could please give us a call back at establishment phone number. Thank you and goodbye, end quote. Respondent replied through counsel stating that the decedent passed away on February 6, 2022, and that the decedent was cremated on February 10, 2022. Respondent dealt with deceased daughter as next of kin, who advised that the family wanted a cremation during a conversation on February 7th. The daughter signed a cremation authorization form on February 7th, 2022. However, the daughter advised she would not be able to pay for the cremation. Afterwards, the uncle, the brother of the deceased, stated that he would be paying for the services. Respondent stated that the uncle did not request or reference funeral services or an identification viewing at this time. Respondent stated they were contacted by phone on February 9th, 2022 by the uncle about potential for an identification viewing. Respondent stated there was no request for funeral services. Respondent further stated that the uncle was not designated as next of kin, and at no point had anyone in the family presented respondent establishment an order appointing him as the administrator or executor for the deceased. Respondent stated that following the telephone conversation, funeral director / embalmer 1 attempted to call the daughter of the deceased. However, the daughter did not answer, and the employee left a voicemail that is referenced in complainant's complaint and was provided in full above. Respondent stated that the daughter did not respond to the voicemail until February 11th, 2 days after the voicemail was left. Respondent further provided an exhibit to show that on the copy of the service fee sheet, there were no notations or markings indicating visitation services. Contrary to that, the only charges documented were for direct cremation. Additionally, respondent provided a blank copy of the fee sheet which designated that a viewing and funeral service are not synonymous services as respondent indicated, complainant seemed to be assuming. Respondent denies that the uncle took control of arrangements other than payment, stating that the daughter handled all of the arrangements, was the only family member to come in person, and that the daughter had signed the cremation authorization form. Since the uncle, as a brother of the deceased, is not the next of kin, and that all next of kin signed the cremation authorization form. Respondent maintains that no next of kin ever confirmed the request for either visitation or funeral services, came to his respondent establishment to revoke or rescind the cremation authorization form, or executed or paid for any additional services. Respondent denies that any viewing or ceremony was scheduled for February 11th, 2022 at 4 p.m., as no one in the complainant family responded to Funeral Director 1's voicemail. From respondent's perspective, respondent establishment was only contacted on February 11th, 2022 to let them know that they were bringing clothes for the deceased. At this time, respondent advised them that no identification viewing or other service had been scheduled and that cremation form was never rescinded because no one had contacted respondent to the contrary, so the deceased had been cremated as originally directed and requested. And to help kind of parse through these dates, I've included a timeline of the events as they've been provided in the information. On February 6th, the decedent passed away. On the 7th, the family decides that they want a cremation for the deceased, and a cremation authorization form was signed. On February 9th, respondent contacted about a potential identification viewing, but was contacted by members of the family that were not next of kin. That same day, on February 9th, the funeral director, Embalmer 1, attempts to call the next of kin and leaves the voicemail that was provided above. On February 10th, the deceased was cremated, and on February 11th, the first contact that respondent had with the family following their February 9th, 2022 voicemail, stating they were bringing clothes for the deceased viewing. So, based on the above, it appears that complainant operated under the assumption that the uncle had taken over the arrangements, and that mentioning wanting an identification viewing or a viewing ceremony was sufficient to put the arrangement in place. Likewise, respondent, having dealt exclusively with the daughter of the deceased as the next of kin who made the arrangement decisions, sought to reach out to the daughter to confirm that that was what the family wished to do. This is evidenced by the voicemail left by the respondent on the daughter's phone 1 day prior to the cremation as purported by respondent. So based on the above, we would recommend a $750 civil penalty for the funeral establishment, to authorize via consent order informal hearing if necessary, and closure for the funeral director / embalmer and for the apprentice funeral director. I guess I'm sure there will be questions because there's a lot of information there, but generally speaking, I think to me this question comes down to a question of professional conduct, which is something you all are much more suited to answer than I am. From a legal perspective, I see why it was a reasonable belief of we're having family members say we want this additional service. I need to reach out to the next of kin to confirm that. To me, the question of professional conduct is if they leave a voicemail on the 9th and cremation is scheduled for the 10th and they don't hear anything, is to what degree of unprofessional conduct, if at all, is it to just go ahead and do what has already been determined that they were doing prior before the idea for a viewing came up. So that is the logic behind the $750 civil penalty recommendation. But again, if you have any questions at all, please feel free.
So who signed the contract? That would be the first question.
From my understanding, that would be the next of kin that they called and left the message with. She signed the cremation authorization form, and my understanding from the information provided is that she was kind of their point person. She'd come in person, had signed necessary documentation, and that this next of kin that they called and left a voicemail with was the person who had handled everything up to that point.
I understand that's the daughter.
Correct, yes.
I've got one. Right on Wednesday, Dr. Baum left the voicemail. Friday the 11th.
Correct.
And he cremated him Thursday the 10th, the very next day. Socket.
Like it didn't follow through for
Yeah.
final
He
permission.
called on Wednesday and left a voicemail saying we want to set the viewing up for Friday the 11th. And then on the 10th, he was
Kind of what the respondent had provided in their response regarding that point. They said they didn't provide times, but I'm under the impression that that call was made fairly early in the day and that they had left the voicemail, requested a call back, and when they didn't receive one, essentially from their perspective, good, bad, right, wrong, they said that they had this kind of request from the uncle, who was not next of kin, to do this additional service. They have to go through the next of kin. They reached out, didn't hear anything. So the last marching orders they had from the next of kin was, we should cremate on the 10th. That's their explanation as to why that turnaround was so quick.
Is there a reason why we're not giving a civil penalty to the funeral director here?
So for the funeral director, the information strict against them was, I guess, also sparse. That they were the point person who called and left the voicemail. Not a lot of information was provided exactly against the level of their involvement. The reason an apprentice funeral director is included, and again, the information was a little sparse. I was under the impression from what was provided was that the apprentice funeral director was the one kind of setting up the arrangements. They went on vacation, and they came back, and things had happened at that point. So I'm not sure the level of potential culpability of the funeral director / embalmer. The complainant didn't provide a lot of information. I guess from my perspective, what I see as the most likely and clear potential violations were on behalf of the funeral establishment. I'm not entirely certain of the level of, I guess, involvement of the funeral director / embalmer. But
The questions for legal?
From a funeral director's perspective, from the 6th to the 11th with an unembalmed body is a long time. And it's an unfortunate for the family, but is the daughter the one who is well, I know you can, maybe you can't answer that. Who is complaining?
it is the family there's not one specific individual who is the complainant.
Is the daughter involved in the complaint?
Yes.
Okay. Her complaint is more for the funeral home, not directed toward the funeral director.
I guess one thing I will provide too is that the complainant is represented by counsel, as is the respondent, which is, I would say, rare that we see both parties represented. So understanding that the complaint that I received, I guess, was lawyered up, the information, pretty much it was a multi-page complaint, and from my reading, even though the funeral director and embalmer was listed as a respondent, most of the, I guess, focus on the facts and everything that was provided to me read as primarily against the establishment, to me at least. And again, this is something you all would know much better than myself, but to me that was kind of, the events here were more of a like large scale establishment decision, as opposed to, I don't know to what degree of control the funeral director individual may have to just say, nope, we're gonna cremate. So that was my interpretation, is that kind of the most involved respondent party here would be the establishment, not the individuals. But again, I have gaps in knowledge of this field, so.
The funeral director specifically said Friday at 4 o'clock, and I know he left, or she left, a message. So this is my personal opinion, and this is not in a form of emotion. They should be held accountable, or the funeral director should be held accountable as well, to some degree. If I leave somebody a message and say, we're going to do such and such that day, that is the professional part of my word to say, this is what we're doing. Now, granted, things get busy in the back. There's a deceased back in the embalming room, and it's now the 10th after 4 days. There are some issues that come up. So, it's, I don't know.
I feel like the funeral director neglected to do that final diligence to call and at least say, we're here, we're ready to move to the cremation stage. Are you okay with that? And it seems to me like what you're feeling, they've just bypassed it. I'm struggling with this one.
Yeah, basically, the funeral home was put on notice that they wanted a viewing, but clearly the daughter's the next of kin, and even though the uncle paid, that doesn't change any of that. She's still next of kin, so I think the funeral home absolutely did the right thing by trying to get the consent, but I think not giving more than just 24 hours to hear back is a problem. So I think that's the bottom line, is there should have been given more time or another call, as Mr. Harris said, to the family to confirm whether they did or did not want a viewing. But I absolutely believe the daughter should have been the one given consent for that. But to go ahead with the cremation, knowing you've asked, hadn't heard back, I think that leaves them with some liability there. So
Robbed of that opportunity of viewing their loved one.
I'd make a motion to approve council's recommendation.
Second.
Any other questions or discussion? I have a motion by Mr. Berry, second by Mr. Lee, to accept legal's recommendation, $750 civil penalty with a authorized via consent order, formal hearing if necessary. All in favor?
Aye.
Any opposed? Next.
And the final one is a represent from last month's board meeting. It is complaint number 2022-035741. This was the one where complainant alleged unprofessional conduct, that they had not been paid for their services. They stated that as of November 1st, 2022, respondent had not paid the bill. Services performed occurred shortly after the death of the decedent, which was back in November of 2021. Complainant said that they have spoken to respondent on the phone. They contended the bill would be paid, and they allege that they have received no payment for the outstanding invoice. And the represent portion is, at the time, respondent did not respond to the complaint. So respondent submitted their reply to the department on November 7th, 2022, one day before November's board meeting. Due to this, respondent's reply was not received by legal in time for last month's meeting. Respondent confirmed that they had contracted with the complainant to pick up and embalm the deceased. Respondent stated that the family used life insurance to pay for the funeral services, and that because of this, respondent establishment had to wait for the death certificate, which was to be provided by complainant, to send to the life insurance company. Respondent contended that it took 6 months for the complainant to send the death certificate. thus delaying the process. Respondent stated that even after receiving copies of the death certificate, complainant did not send certified copies of the certificate, so new certified copies had to be obtained from the medical examiner determined death in the foreign state that the complainant resided in. Respondent stated that in total it took about 7 months to receive the certified death certificate. Respondent admitted that they do owe complainant the stated amount, but contended that complainant submitted a complaint before he could send payment. Respondent concluded by saying they would send the complainant their check this week. Complainant provided a rebuttal stating that they had sent the death certificates to the family, and the family confirmed that they too had difficulty getting in touch with the respondent. Complainant contends they never agreed to wait for the insurance to pay, and that respondent had represented that they would pay them as soon as possible. Legal contacted complainant to determine whether they had received payment. Complainant confirmed that they had not at this time. So, new recommendation would essentially just be that the board's determination to remain the same, a $2,000 civil penalty. The reason for bringing this back for represent was with them submitting a response, albeit one day before the meeting. I wanted to at least be fair and let the board hear their side of the story and their events. Under the rules, your window for response is essentially 2 weeks. And if, technically speaking, if you submit a response 15 days, that is a violation. If you submit a response, up until the day before it's presented, that's also a violation. So that's, even though we received a response, that's why legal is recommending that the civil penalty remain the same.
Any discussion for legal?
I think that is a common issue based on years of experience about how quickly you get paid when you're asking for assistance. And I think you got to be diligent in confirming that payment. So as soon as possible isn't that what that means to one person may be different from what it means to another. But it is very frustrating when you can't get paid for services rendered, and really the statutes don't state when a funeral home has to pay that. So just a comment.
So, refresh my memory. When did, I guess, the service portion of this happen that this respondent has not paid?
It was back in November of 2021. So it's been, at the time of presentation last month, it was right at a year. It's been essentially 13 months at this point.
So do you feel 2,000 is fair, or should we go more here?
Personally, I do feel 2,000 is fair in the sense that from their response, I don't know that anything has changed other than the sense of we're another month removed. Essentially, I know it was discussed last time that essentially it's $1,000, the way it was stated, $1,000 civil penalty for lack of responsiveness, which is still the case. We got one, but not in the time frame required. And $1,000 for unprofessional conduct for failing to pay for services required. So I feel from my perspective that 2,000 is still a consistent and fair civil penalty assessment because, again, we're essentially in the same place we were last month, just another month down the line.
I think the history against Otter is important to look at.
And we may have discussed this before, but as a new board member, if someone doesn't pay that penalty, what is the penalty for not paying a penalty?
Sure. So essentially at that point, if they refuse to sign the consent order, I would essentially draft a document which is called a notice of hearing and charges, and they would come before the board. And it's, I guess, a clunky metaphor would be we would have an administrative law judge sit in, and you all would essentially be the jury, so to speak. The judge would make sure evidentiary things were, we did all the legal things correctly, basically. And they would come before the board, and they could put on proof. We would put on proof as well. And at the end of that hearing, the board would make a determination after hearing all the proof.
The fact that it still hasn't been paid, it's be held accountable for that.
Feel like 2,000 is minor in this case. That's my
Well,
opinion.
you know, and trying to get their and apparently previous finding or not findings, but decisions made by this board hadn't got their attention. So
I'd like to make a motion that the board recommend a $2,500 civil penalty to the respondent.
Second it.
All right, we have a motion by Ms. Stevens to change the recommendation from a 2,000 civil penalty to 2,500. Still with an authorized via consent order, formal hearing if necessary. Second by Mrs. Haynes. Any further discussion?
just one question. So that's only for the funeral establishment, right?
Correct. Yes.
Why would like the funeral director or the manager for that not be held liable for that as well?
That's a good question. I guess what we received was just a complaint against the establishment. So we are sometimes a little bound by what the respondent that the complainant files it against. In this circumstance, I am under the impression that the person that the complainant, in my conversations with them, has been dealing with is the owner of this establishment and the manager. So it's even though I guess it's against the establishment, since that's who the respondent filed it against, I think it encompasses the manager owner as well.
So just as a question,
Sure.
if it comes in a complaint against the establishment, can this board also find the manager, therefore the funeral director, responsible for this as well, or do we clarify that for me?
Sure. That's one that I'll be honest with you. I'm not 100% positive, and I don't want to tell you the wrong thing. I can make a note to take a look and be happy to get back to you on that. But I do know one thing, just as kind of a manner of policy, is that the department is a little wary of, I guess, using this as an example, if we decided that we need to loop the funeral director in as well, we would essentially have to administratively open the complaint. And I do know that a little more careful with those, just that it's, when the department gets a little more involved in complaint matters like that. So I would say at best, there would probably be a little bit of trepidation on that, but I will find out for sure if that's
Just curious, and then
Sure.
we oftentimes have discussions about follow-up, and so if there was a follow-up to ensure that this was being paid, and then some type of condition if it was not paid, what can you clarify if we can do anything regarding that? For instance, if this isn't paid within the next 30 days, then another step takes place.
Yeah, I think as far as the board's determination, it's a consent order is essentially an agreement. If the opposing party, if the respondent chooses to sign it, essentially can put whatever the board decides to do in there, so long as the respondent agrees to it. So if there's, I guess, something specific the board has in mind for that, then that's something I don't mind putting
For
it.
example, you said like having a hearing. So if it's not paid within 30 days, then we require them to come for a hearing.
Yeah, I mean that is a possibility for sure. One thing I will say too is that I do know. So I haven't done a hearing on this side. I have done or set up for a hearing on the burial services side, and they are kind of they're involved, so to speak, which is fine. And if at the end of the day, what the board needs to do is get this individual in front of the board, then that's perfectly fine. I'm perfectly happy to do that. I guess I would personally caution on it kind of reserving hearings in that sense and more using them in the sense of here's the board's determination of civil penalty, are you going to pay it, yes or no? The answer is no, then we do a hearing, as opposed to it being kind of a kickback option, if that makes sense.
So can we give him a, like Mr. Berry mentioned, like a 30-day window? Do we do that, or?
Sure, yeah, I can add to the civil penalty with payment to be issued to respondent within, or complainant within 30 days. And I guess the question would be, if that 30 days if he doesn't pay it, is it a additional civil penalty? Does the civil penalty get higher? Or I guess that would be the question, is if you hit that 30-day mark, what would the board decide to do?
60 days.
Days for payment.
Had to request him to.
Well, as he said, that
That
you know,
gets
the
to-
hearings are time consuming and involved. So I would say, could I amend the motion, or
I guess with Ms. Stevens' approval.
You amend it.
okay? So amending the motion for a penalty of $2,500, and if not paid, you know, through follow up, if not paid in 60 days, that would double to 5,000.
Okay, we have an amended motion by Mr. Berry to change the $2,500 civil penalty to now, or excuse me, yes, $2,000 to $2,500. If not paid in 60 days, then we'll double that to $5,000.
Second.
All right, Ms. Haynes seconds that motion. Any further questions or discussion on this? All in favor?
Aye.
Any opposed? Mr. Bryan, anything further from you, sir?
I think maybe on the agenda a little later, but while I've got the floor, I'll go ahead and jump to it. But just an update on the rules, the pending rules. We're in kind of the last stretch of before they are effective. We have a GovOps kind of meeting essentially to go over them. I'm under the impression that will be in January, and then the rules from the May hearing will be effective in February.
Sir, appreciate your report. All right, we'll move to our executive director's report. Mr. Gribble, good morning, sir.
Good morning, Mr. Vice President and board members. First thing I have is a legislative report. Our office has not received any official notification by either the Tennessee State Funeral Directors and Morticians Association or the Tennessee Funeral Directors Association regarding their intent to pursue new legislation during the upcoming legislative session. We extend an invitation to both associations and any other interested party or parties that would like to meet with their staff and legal counsel to be prior to the introduction of legislation affecting the Board of Funeral Directors and Embalmers. Licensee report is a report of licenses administratively approved with the executive director pursuant to the board's authority for the period of November 5, 2022 through December 9, 2022, and you have the list in front of you. There were no closed establishments to report for this meeting. Disciplinary action report for this meeting is a report of consent orders that have been administratively accepted and approved by the executive director pursuant to the board's authority and as reported on the October 2022 regulatory board disciplinary action report, and you have a list of those establishments and directors in front of you as well. The complaint report for today is we have a total of 30 complaints, 13 of those being funeral director and or embalmer related and 17 related to an establishment. Mr. Vice President and board members, that's my report. I'll be glad to answer any questions you have.
Thank you, Mr. Gribble. Any questions from any board members?
Did we approve the director's report?
A motion by Mr. Berry to approve executive director's report. Do I have a second?
Second.
Second by Ms. Stevens. All in favor? Any opposed? Thank you, Mr. Gribble. We now will move to individual applications for licensure. Mr. Gribble, do we have any individuals?
There are no individuals. One establishment, the establishment that came before you last month, where the board tabled the application for them to do some more work to their building pursuant to a fixed place of business. And today, before you have Bates Love Funeral and Cremation. The proposed manager is Kenley Lewis Bates, to be located at 530 Highway 64 East, Suite 6 in Waynesboro, Tennessee. It's a limited liability company owners, Bates Love Funeral and Cremation LLC, located in Waynesboro, Tennessee.
All right, thank you. And we'll open the floor for you, Mr. Bates.
Well, I just appreciate the opportunity to be here and for you guys to look at it this morning.
So basically, you've added the temporary partition around the conference table area you're meeting with the family.
Well, we've added that, and not based on any suggestions, but we had done some work prior to the last board meeting, but after the pictures were taken. And so in your new pictures, you should see the coffee bar area in the back. There's a refrigerator that is stocked with water for the families. We do have the partition. The desk has been moved toward the front. The end tables and lamps had been added after that. I believe it was after that. And even since the pictures that he took for the re-inspection, we've added new sofas rather than the ones you have pictures of. But they just came in yesterday.
I think all those are great enhancements. Still just concerned, about the sound barrier, and just if you're meeting with a family, I think you meet minimal requirements. But personally, I would encourage you. I think it'd be difficult to be waiting on a family and providing service excellence to them while somebody else may be talking on the phone, or other people being waited. Maybe you have folks in there on the couches waiting to be met with, that type of thing. This almost lends itself to serving, one family at a time. And, what I might encourage you to do is, during that time you're with a family, have the phones transferred to an answering service or something like that, where you can give complete attention to that family and there's not the interruptions in there.
Yes, sir, and that is our intention. There's three of us kind of working this together, and so I do not want the phone just sitting there ringing because obviously it is a small room. But yes, we have thought of that, and that is our intention.
I'm still struggling with the fact of the respect solely for the family you're waiting on and the privacy of that family. Everything can be heard in this type of setting. That's where I'm struggling with this.
If I could comment on that, I understand fully what you're saying, and so what our intentions are is to schedule appointments when we're meeting with families. And I don't know that I would say the office would be closed, but we don't really intend for people to be walking in and out freely. If that means one of us kind of sits and watches for the door to meet people on the other side of it, or whatever we need to do for this temporary time. But I do understand what you're saying.
So I know last time you said temporary and you're working on something else. Do we know where that timeline still is?
I do not. We've had a software issue with the fire marshal's office, and so we are just waiting for that to process through.
I have a scenario I'd like to bring. So you're meeting with a family behind the temporary partitions. Thank you, Mr. Berry. And it is common for people, especially with a new operation, to stop in unannounced for information for funerals. And having someone stop by for general price list or questions about a funeral, I think it'll be very difficult, especially with a new organization, to tell them to come back at another time. How will you handle that situation?
Well, if they wanted a price list or any questions answered, I feel as though we could answer those questions, provide them the price list, certainly, but it wouldn't necessarily have to be done inside. I guess that's what I was referring to, is if somebody's meeting with a family, to have someone else there, and if somebody does approach the door, we could meet them in the front half of the building and simply politely explain that we're meeting with a family and could we help them, and that would create more distance between the door and the family.
I personally struggle with, but I guess it's kind of broad in the fact of how this board can look at a facility. I asked, I think, the question last meeting about more specifically, if the board thinks that any office should at least have 2 rooms to it for privacy to deal with the concerns that we're talking about. To me, that really needs to be in the language as a requirement, but it's not. So it's very difficult, in my opinion. But at the same time, I have a difficult time in saying that you don't meet the minimum qualifications. But I think based on the way you're set up, it's going to be hard for you to offer service excellence. And I think that's what your desire is to do. I would encourage you to either have signage outside letting folks know that you're currently meeting with a family.
We did talk about that last meeting as well.
It's just not. To me, it's not the ideal situation, and it's not the way that I think this board wants every funeral home in Tennessee and every establishment to offer service excellence to the community. But again, I would have a hard time denying the application. So I'm just going to step out there and say, I encourage you to try to look at making changes to, or again, to deal with one family at a time and try to professionally handle folks, like Ms. Stevens said, who might stop by. But I'll make a motion to approve.
Second.
I have a motion by Mr. Berry to approve the establishment as presented, second by Mr. Lee. Any further discussion or questions?
I do.
Yes, ma'am.
On behalf of this board, I think our hands are tied, and we just hope that you will act as professional as possible to represent the industry.
I would say to you, Ms. Stevens, and all board members for that matter, that we certainly will. This is a profession that we take very seriously and are proud in the service that we hope to provide.
Any further discussion? All in favor?
Aye.
Any against? Aye. All right. Motion carried, yes. All right. Thank you for presenting, and Ms. Bohannon will get with you after the meeting. All right. We will, Mr. Gribble, anything further from you before I move on? So good.
You're muted.
Nothing further from me, Mr. Harris. The only thing, Ms. Bohannon and I were working with some video things, and I know there was one no there. I don't know if that person wants to be recorded as voting no in the minutes, and Ms. Bohannon may have the name of the person. I failed to get it.
Okay. And
I
it was I, and Ms. Bohannon said she did have that.
Okay, thank you.
Thank you.
Can I ask Mr. Gribble a question?
Yes, please.
Mr. Gribble, going back to that application, and again, as Pam said, our hands are kind of tied on these matters like this. But for us to change or edit some of the qualifications for an establishment license, what would that involve? Can that be done through rulemaking, or is that statute, or?
Definitely by statute, and then legal counsel could look into about rulemaking, except we're going through a pretty comprehensive review of the rules through the department now. So I would suggest now is not the perfect timing to do it through rule. But like counsel said earlier, we'll be glad to, whatever direction you give us, we'll be glad to follow that. Of course, statute would be, that's unquestionable if it passes in statute. It's and there might be some question as to whether if it was done through rule, and again, legal can opine on this at the time. But if it was attempted to do that by rule, there might be some question as to whether or not the board has the authority. The statute gives the board authority, and it may do it. It may very well do it. When we did rules about this before, a previous board and legal counsel talked about it at the time, and the decision was that this gives some pretty wide interpretations to the board, and the board, it's one of those things the board either knows it's right to do or it's wrong to do. And that was kind of why it was left so open before regarding a fixed place of business. There were some additional things put in the rules back at that time, but it was decided not to go down further and get down into the layers and make it more specific, so that it would give some leeway to the board and discretion to the board in making the decision on the application. But I understand that thinking may have changed, and this board may want to move forward in a different direction.
Thanks. I was just interested in, if we, because I think you're going to see this more and more, and there's going to be more applications come up. So, but as we all know, the industry is changing, and the business models are changing, and families' expectations are even changing of what they expect. And if families are satisfied with that level of service and happy, and it's a lot to consider. So I was just curious. It's something that the board may want to discuss in the future, or we each talk to our association about that. And so thank you.
Mr. Bryan, is that something maybe you could possibly check into and report back to us at the next meeting, what our possibilities are?
Yeah, absolutely. I already made a note to follow up on that, and I do agree with Mr. Gribble that right now is a bit of a complicated time for rulemaking, but at the very least, I can check into that, do the groundwork, see what our options are.
Thank you. Anybody else comments for Mr. Gribble? All right, we'll move to the next item. It's the election of board officers for 2023, and we will open the floor for nomination on the position of president.
Yes, I would like to nominate Anthony Harris as our president.
Second.
All right, I have a nomination by Mr. Berry to nominate myself for president, and I'm honored. I appreciate that. Ms. Stevens as a second. Anybody else? All right, we'll close that for nomination. All in favor?
Aye.
Any opposed? All right, we'll move to vice president position, and we'll open the floor for nominations there.
I'd like to make a motion.
We're on mute if you could do that one more time.
Can you hear me now? I'd like to make a motion to nominate Ms. Tanya Haynes for vice president position.
I'll second.
Okay, have a motion by Mr. Lee to make Ms. Haynes our vice president, second by Mrs. Stevens. Any other nominations? And we will close for nominations. All in favor of Mrs. Haynes as vice president?
Aye.
Any opposed? All right. We will move forward to the appointment of the continuing education liaison for 2023, and we'll open the floor for that nomination.
Nobody expressed interest in that one.
Well, you've done it all this year.
Is there any interest of anyone? Looks like Mr. Lee's nodding his head. I'll nominate Mr. Lee for that position.
I'll second.
All right, we have a nomination for Mr. Lee as our continuing education liaison for 2023, second by Mrs. Stevens. Any further nominations? All right, we'll close that. All in favor?
Aye.
Any opposed?
Mr. Lee, it looks like you just got voluntold.
All right. Appreciate all the nominations and look forward to 2023. And we will open the floor now for any new business to discuss. I will say, and I'll pass this along, Mr. Rahm was very sad he couldn't be with us today, and hopefully he'll get another opportunity, one more chance to be with us before his appointments of replacement. Any other business?
Move we adjourn.
All right. So I have a motion by Mr. Berry to adjourn, second by Ms. Stevens and Mr. Lee at 11:06. Are there any not in favor? All right. Everybody in favor say aye.
Aye.
All right. We are adjourned.
Thank you, Mr. Harris.
Thank you.